Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
All right, guys. Mr. Msur is back in court, and this time he's about to learn exactly why having legal representation can make such a huge difference. If you're watching this for the first time, this is part 2 of a previous hearing we covered on the channel. Daniel Msur has already made things difficult for himself by refusing to properly answer the judge's questions and trying to handle everything on his own. From the very beginning, his attitude becomes the biggest issue. Instead of working with the court, he seems determined to challenge every step of the process. And the fact that he shows up without an attorney while facing serious legal issues only makes things more complicated. Even small things, like appearing in court chewing gum, give the impression that he doesn't fully understand how serious the situation is. This hearing is a perfect example of why courtroom strategy matters. Let's see what happens when Mr. Msur and Judge Simpson go head-to-head again.
And so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a prelim.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yep.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This hearing is a great example of how difficult it can be to represent yourself in court, especially when emotions and legal strategy are involved. Mr. Msur appears determined to argue every point himself, but the problem is that courtrooms are not won by confidence alone. Judges focus on facts, procedure, a valid reason for taking control of his own case. Let me know your thoughts in the comments. If you enjoyed this courtroom breakdown, make sure to like the video, subscribe to the channel, and stay tuned for more real courtroom moments. Thanks for watching. And legal arguments, not just personal opinions or frustration. His approach creates even more tension because instead of answering questions directly and moving the hearing forward, he seems focused on challenging the process itself. That kind of behavior can make an already difficult situation even harder. When someone is facing serious allegations, including claims involving an assault on a police officer and family-related consequences, every decision inside the courtroom matters. Having an attorney isn't about admitting guilt or giving up control. It's about having someone who understands the legal process and can protect your interests. And watching this hearing unfold shows exactly why many people choose to have professional representation when the stakes are this high. What do you think? Was Mr. Msur making a mistake by representing himself, or do you